Hello, everyone, and welcome to Uncivil Law. For today's case, we are doing an excess force claim. The police did bad things, they used too much force. And this is a recent case. It was just decided in the case of Lamar Wright versus the city of Euclid, Ohio. So, we're going to read a little bit about this and what is happening in Ohio. Let's get started with this. On November the 4th, 2016, at around 6 p.m., Lamar Wright pulled an SUV onto a residential driveway in Euclid, Ohio. After Wright rolled down his window, conversation ensued with a friend who stood outside the residence. The friend never came over to the SUV, and Wright never exited the vehicle. Their visit lasted about a minute. Unbeknownst to Wright and his friend, a plainclothes officer, Kyle Flagg and Vashon Williams, in an unmarked vehicle were surveilling the friend's home based on reports of illegal drug activity in the area and at that residence in particular. The officers identified Wright's vehicle as a rented Ford Edge SUV. Based on the short amount of time Wright had spent at the home, the officers suspected he may be involved in a drug transaction. In a drug transaction in which he never left the car and the person he was talking to never approached the car. A very strange drug transaction indeed, but okay. So after Wright pulled out of the driveway, Flagg and Williams followed him. The situation escalated after Wright pulled into a second test driveway to answer a text message from his girlfriend. So he's being a good driver and not texting while driving. While Wright texted in the SUV, officers exited the vehicle, drawing their guns as they approached the SUV. One of the men caught Wright's eye when he glanced up from texting. In the side mirror, Wright could see the man dressed in dark clothing with a gun pointed at his SUV. Because remember, they're plainclothes officers in an unmarked car. So what he sees is a couple people who are just approaching his car with guns drawn. Because that's how well this is going. That's genius. Believing he was about to be robbed, which is a pretty reasonable conclusion, Wright dropped his cell phone in the center console and threw his car into reverse, which seems like a reasonable thing to do. Glancing to his left, he saw another armed man, but this time he noticed a badge. So somehow there was a badge out or display that he was able to see. Wright heard a man yell, "Shut the car off, open the door." Now realizing the men were police officers, he put the car in park and put his hands up. The police are just handling this super well. They didn't announce police. They didn't do any of those things. No, they're just unmarked car and unmarked people with guns drawn. And this guy is responding as appropriate. And the police say, "Oh, we felt threatened." And of course, these events are corroborated by body cam footage, which is always helpful. At this point, Flagg stood up beside the driver's side door, while Williams was next to the passenger door. Both officers holstered their guns. This is going super, super great. Flagg then tried to pull Wright from the vehicle, but the latter had difficulty getting out. As noted, Wright had recently undergone surgery, which required staples in his stomach and a colostomy bag. So he was having difficulty getting out of the bag because of this recent surgery. As a result of this effort to pull him out of the car, Wright began bleeding from his staples that attached the colostomy bag to his abdomen. After Wright's arrest, a hospital doctor treated him for bleeding in his abdomen because of the stress put on his staples. Wright refused to submit to an x-ray because of his recent surgery, so they wanted to x-ray him, but Wright said, "No, I don't want to be x-rayed." The officers responded by demanding a scan of his abdomen, presumably to look for drugs, but the doctors refused to perform the scan after consulting with the hospital's legal department. Yeah, good. The police can't require the hospital to do anything without a court order. And so good on the legal department. If he wants to get a scan for his own purposes, good on them. And then they can't get access to the records anyway because they're confidential and all that stuff too. But the police want a CT, they want a scan for the drugs because they think he has drugs in his abdomen for some reason. Okay, that's great. So the doctors refused to do this scan because their legal department told them no. Wright was then discharged from the hospital and taken to the jail. At 10:45 p.m., Wright was charged with 2 misdemeanors for which he was arrested: obstructing official business and resisting arrest, along with 2 other offenses: criminal trespass and failure to use a signal. Despite the fact that Wright had no drugs when he was arrested and was not charged, the officers designated the arrest as stemming from a drug investigation, which then would require more thorough searches, so that's great. Wright posted bond between 11 p.m. and midnight, but he was not released from police custody. Okay, no, that's not how that happened. He has posted bond. He is now bonded. In other words, he is allowed to leave. So he was arrested for something. The judge gave him bond. He has posted bond, and now he is free to leave. but the police are now refusing to let him leave. Now we're into false arrest. The police are engaging in false arrest because they have no cause to detain him because he's posted bond. So, but the police are saying, no, you can't leave. So we did a false arrest. We did excess force. We pepper sprayed. We used guns. We wanted to get a scan, and we're saying, no, now you can't leave even though you're bonded. So now we're conducting kidnapping. We are kidnapping people at this point. That's just great. As Wright was attempting to leave, a corrections officer told him he'd be taken to a jail for a body scan to see if he's hiding. You can't do that. He's bonded. He's no longer in your custody. So you are now, without right, moving him from one place to another. That's kidnapping. So anytime we want to charge the police criminally would be fine, because we just committed kidnapping, but of course we're not going to do that because the police are special or something. Shortly after 1 a.m., he arrived at this new facility where the JAF searched him using a body scanner, which turned up nothing, and then he was released from custody at 3:55. Over the next 7 months, all the charges were dropped against Wright. Are we going to bring up the charges against the officer at any point? No, because those charges don't exist. Neither Flagg nor Williams was investigated for the discipline, and their use of force was deemed appropriate. Even though we literally have engaged in a conspiracy to kidnap, we're not going to mention any of that, but that's okay. Wright argues his injury is directly attributable to the city's policy or custom of indifference to use of force. Euclid police undergo defensive training tactics that purportedly train officers in methods to defend themselves or defuse the situation. Flagg maintains he used these defensive tactics in subduing Wright. All right, so we want to sue the police officers and we want to sue the police officials, right? So we want to sue the supervisors or we want to sue the city. That means we're under a Monell claim. We all know Monell with something we've been covering more and more of the channel, right? We want to go after the officers, 1983. We want to go after their supervisors. We want to go after the city of Euclid. We're under Monell. Now, as we've covered before, we can't do vicarious liability. So we can't get there because our employee did a bad thing. So in order to get to the city or the supervisors or any of those people, we have to show a bad thing they did. We have to show bad policy, bad training. We have to show indifference. So what did the city do? What did the supervisors do that was bad? Did they do a bad thing? Well, let's find out. Here's some things that they did. Let's find out if these are bad things. So during a training session, during an officially sanctioned training session by the Euclid police, and during a mandatory training session, this is a thing that happened. There was training, and the training included a link to a YouTube video of a Chris Rock comedy skit. The skit is entitled, How Not to Get Your Ass Kicked by the Police. The video, again, official training, the video shows numerous clips of multiple police officers beating African-American suspects. During the video, Chris Rock says such things as, again, official training. So Chris Rock is now engaging in official training of the Euclid City Police. He may not have known he was doing that, but that's what's happening. Chris Rock says, police in the black community often wonder that we may be a victim of police brutality. So as a public service, this Chris Rock show proudly presents this educational video. Have you ever been face to face with a police officer and wondered, is he about to kick my ass? Well, wonder no more. If you follow these easy tips, you'll be fine. We all know what happened to Rodney King, but Rodney wouldn't have gotten his ass kicked if he had just followed the simple tip. When you see the flashing police lights in your mirror, stop immediately. Everyone knows if the police have to come and get you, they're bringing an ass kicking with them. If you have to give your friend a ride, get a white friend. A white friend can be the difference between a ticket and a bullet in the ass. Chris Rock, How Not to Get Your Ass Kicked by the Police, link to YouTube is provided. Sergeant Morosky conducted use of force trainings and reviews all incidents involving use of force. He stated that he thought this video, which again was used during official training exercises by the Euclid police, he thought this video was humorous and relates to things that the Euclid police officers have experienced. The city's use of force training also included a PowerPoint presentation, the first page of which depicts a stick figure cartoon portraying a police officer in riot gear beating a prone and unarmed civilian with a club with a caption that says, quote, protecting and serving the poop out of you, unquote. Sergeant Murkowski testified he did not believe the graphic conveys that the Euclid Police Department beats the hell out of people, but he didn't know what other message could be taken away from the image. So we have, as part of our training, a Chris Rock video and a cartoon, both of which involve beating people. And we're like, we weren't training people how to beat people. Really? What other message could be taken away from it? Yeah. So way to go, Euclid Police, you shine on. When the Euclid Police Department reviews allegations of excess force, Sergeant Murkowski reviews the relevant incident report to determine whether the use of force was appropriate. Murkowski approved of this use of force against Wright, as he's done multiple times with respect to other incidents. How many times has he approved of use of force? In fact, he testified that he's never even heard of a use of force that he deemed to be inappropriate. They're all fine. All of them are great. We've investigated ourselves and we see no problem. Outstanding. Likewise, the chief of police testified he never found merit to any civilian complaint concerning use of force. They're all fine. All of them are fine. All of them are great. No problem. Our training is great. There's no problem on our training. Excellent. Most of Wright's arguments hinge on whether these officers, as stellar as they are immune to suit through qualified immunity or statutory immunity under Ohio law. We analyze whether an officer is entitled to qualified immunity using two steps: whether the defendant violated a constitutional right and whether that constitutional right was clearly established. We know this very well. A similar inquiry applies to statutory immunity under Ohio law as well. We must now decide whether, accepting Wright's version of the facts, the officer drawing his weapon and his using a taser violated a constitutional right that was clearly established. For this prong of the qualified immunity analysis, we are not to define the clearly established law at a high level of generality. We examine this by considering whether the contours of the plaintiff's constitutional rights were sufficiently defined to give a reasonable officer fair warning the conduct was unconstitutional. That's not to say that an official's action is protected by qualified immunity unless the very question has been previously held to be unlawful, but is said to be in light of the pre-existing that the unlawfulness must be apparent. With respect to an officer's use of a firearm, we've recognized that pointing a firearm at an individual and making a demand of that individual communicates an implicit threat that if an individual does not comply, that one might be shot. We've also recognized that pointing a gun at an individual can constitute excess force under the Fourth Amendment. Also, it's against the fundamental rules of using a firearm. One of the fundamental rules of using a firearm is don't point a firearm at anything you don't want to destroy. So we are just, not only are we violating constitutional rights, we're violating one of the basic rules of firearms. That's great. In conducting the analysis as it pertains to a taser, two lines of cases have emerged. The first hold that there's no clearly established right not to be tased when a person is actively resisting arrest. To summarize, a reasonable jury could find that Flagg's actions constituted an unreasonable and constituted an excessive force. It was clearly established in November of the 4th, 2016, that drawing a weapon on a suspect who is not fleeing or posing a safety risk and tasing a suspect who is not actively resisting arrest constituted excessive force. So yes, that was clearly established as to that officer, so that's good. As to Officer Wright, he may not have tased him, but he did brandish a firearm, and he used pepper spray. So that largely mirrors the claim against Flagg based on a similar use of firearm and tasing, and therefore the analysis is roughly the same. In a case called Adams, we held summary judgment was inappropriate for excessive force claim brought about by a police officer who used pepper spray, when it remained genuinely disputed whether the plaintiff had committed a crime, where he posed a threat, and whether he was resisting arrest. So if there's no threat, you can't use the pepper spray. Okay. The body cam footage in this case, the body cam footage in question, shows that Flagg was attempting to gain control of Wright's arm. Williams reached into the car with his can of pepper spray and sprayed Wright within inches of his face. Excellent. Well done, Euclid. Wright's expert opined that the use of pepper spray at this close a distance was unreasonably dangerous and violated nationally accepted standards and protocols, which dictate that the pepper spray should not be used on someone closer than 3 feet away from the canister's nozzle. Way to go. We're pepper spraying it directly into his eyeball. For some reason, that's great. Wright further claims that both Flagg and Williams failed to intervene in order to protect him from alleged excess force committed by the other. In order to establish such a claim, Wright must prove that an officer observed or had reason to know the excessive force would be or was being used, and an officer had both the opportunity and means to prevent the harm from occurring. In Smith, we held that when one officer was occupied trying to gain control of arms while the officer was deploying a taser, no reasonable juror could find the officer had an opportunity and means to prevent excessive force. So it's based on our ability to observe and correct it. Likewise, no reasonable jury could find constitutional violation in Williams' failure to prevent Flagg from using his taser. So Williams isn't responsible for that. Flagg is responsible for that. Williams is responsible for his own stuff, but he's not responsible for failure to intervene because he was too busy violating the rules himself to take notice of his partner's violation. So yeah, you can't get him for that, but you can get him for the other stuff. Therefore, we affirm the district court's grant of summary judgment with Flagg with respect to failure to intervene. So that part will be dismissed, but the other parts can go forward. Now we need to talk a little bit about the extended detention because he was detained past the point when he should have been released. So let's cover that. Under Ohio law, when a defendant posts a bail, he should be released. The approximate 4.5 hour delay in his release was caused by the designation of his arrest as drug-related, which shouldn't matter one way or another. At the time the drug's designation occurred, both Wright and his SUV had been searched, and no drugs or other contraband had been found, so we already had done our search. Nor were drugs or other contraband found on him when we searched again by officials of jail, and he was never charged with any offense. Despite the officers having no information that would give them additional probable cause, because that's over now, because he's been bailed out, and we've already done the search, so we've already done that. Wright was seized for 4 hours after he should have been left free to go, and he was moved from one place to another place, which incidentally is a crime. A jury could find this detention violated his right to be free from unreasonable seizure. Yeah, that's false imprisonment on the civil end. And on the criminal end, it's kidnapping. We have, with force and without authorization, moved someone from one point to another. That's kidnapping. So anytime we'd like to charge the officers with kidnapping would be just fine by me. Unfortunately, that looks like it's not going to happen. So we'll have to do with our wrongful arrest and false imprisonment. But yeah, we should be able to get monetary damages because, yeah, we already exhausted all of our rights. He was bailed out. I meant we had to let him go. So yeah. So that is the end of the case of Lamar Wright versus the City of Euclid. In this case, we learned that City of Euclid trained its cops by teaching them to beat suspects. And then that happened, and that was bad. A person went to visit a friend, and without him getting out of the car or his friend approaching the car, they somehow concluded this was a drug deal. It's the best drug deal ever. No one gets anywhere close to anyone, but somehow it's drugs. And so then they go up to him in an unmarked car with them wearing plain clothes, and he thinks, "Oh, I'm about to get robbed." He puts his car in reverse to try to escape. He finds out they're police. He stops, and then they tase him. They put pepper spray into his eyeball, and they rip out his colostomy bag. And then when he's bailed out, they refuse to let him go. And so, yeah, there were many, many violations of rights that occurred here. The use of a taser was bad. The use of the pepper spray was bad. The use of the guns was bad. Him being detained after he post bail was bad. And so, yes, you can go back to jail and you can sue all these people and get some monetary damages. So good luck, Mr. Wright. It sounds like you got hosed, and I hope you get some serious monetary relief because it sounds like you deserve it. And that's the end of the coverage of this case.